Most people hear the word trust and assume their assets are automatically protected. It's one of the most common misconceptions in estate planning, and it leads to some genuinely expensive mistakes. Here's the truth. A revocable trust is mainly a tool for control and organization while you're alive. It is not a shield. At least, not in the way most people think. The reason comes down to one core detail. A revocable trust can be changed, amended, or canceled by you at any time. Because of that, the law still considers you the owner of everything inside it. And that one fact changes how the trust is treated in almost every important situation. No real asset protection. Because you retain full control, creditors can generally reach the assets in a revocable trust just as easily as assets held in your personal name. This applies in lawsuits, divorce settlements, bankruptcy proceedings, and certain government recovery programs like Medicaid. If you put your home in a revocable trust thinking it's now protected, it's not. If you get sued, that home is still on the table. Legally speaking, nothing left your ownership. Only an irrevocable trust can offer true protection from creditors. A revocable trust also has no separate standing with the IRS. It is classified as what's called a grantor trust, which essentially means it is invisible for tax purposes while you're alive. All income generated by assets inside the trust, rental income, dividends, capital gains, flows directly onto your personal tax return. There is no separate tax filing, no tax reduction, and no separation from you as an individual taxpayer. Changing the title of an asset from your name to the trust's name does not change how it's taxed. Not a single thing changes on your tax return just because the title changed. This confuses a lot of people. During your lifetime, a revocable trust typically uses your social security number, not a separate tax ID. An EIN, or employer identification number, only becomes necessary after your death, when the trust becomes irrevocable and must file its own returns, or in certain banking and administrative situations. While it is possible to obtain an EIN during your lifetime for banking convenience, it does not change the tax treatment in any way. Your income is still reported on your personal Form 1040. Funding is what actually makes it real. This is where most trusts quietly fail. Creating the trust document is step one, but it is only paperwork. A trust that hasn't been properly funded is essentially an empty safe. It looks like a plan, but nothing inside is actually organized or protected. Funding means physically transferring your assets into the trust. Real estate requires a new deed filed in the trust's name. Bank accounts need to be retitled or linked properly. Brokerage accounts require updated ownership or beneficiary designations. Business interests, like LLC membership, need to be formally assigned. Skipping any of these means that asset would likely end up going through probate anyway, completely defeating the purpose. To be clear, a revocable trust is a powerful tool, just not for asset protection or tax reduction. Its real strengths are elsewhere. First, it helps avoid probate, the court-supervised process of distributing your estate after death. Without a trust, your family may face months of delays, frozen accounts, and public court proceedings. With a properly funded trust, assets can pass directly to your beneficiaries according to your instructions privately and quickly. Second, it plans for incapacity. If you become unable to manage your own affairs due to illness, injury, or cognitive decline, a successor trustee can step in immediately without waiting for court authorization. This can be critical for families who need continuity of financial management without a legal battle. Third, it organizes the transfer of assets smoothly and privately, so your family isn't left guessing or navigating a complicated process during an already difficult time. As of January 1st, 2026, the federal estate tax exemption was permanently increased to $15 million per individual, or $30 million for married couples, under the One Big Beautiful Bill Act signed into law on July 4th, 2025. For most families, federal estate tax is no longer an immediate concern, which makes the flexibility of a revocable trust even more practical as a starting point. This makes the flexibility of a revocable trust even more practical as a starting point. But remember, state taxes still apply. However, state estate taxes still apply in some states with lower thresholds, so the picture isn't the same everywhere. The key takeaway: the trust itself is not the strategy. The structure combined with proper funding is the strategy. Most people stop at "I created a trust" and consider it done, but the real difference comes from what actually gets moved into it, and how it's maintained and reviewed over time. If asset protection is what you're after, that's a separate conversation. The right tool depends entirely on what you're trying to accomplish.